Whistleblowers always ask us, or potential whistleblowers always ask us, what, if any, backlash can they face? And the truth of the matter is that when an employee steps forward and blows the whistle, to some degree, it's a little bit harder, if not a lot harder, for an employer to take action against that employee. And the reason is that once the employee has gone on record with the United States government or a state government and stepped forward, there's a solid argument to be made that, assuming everything else is equal, that is to say that there's no employment problems, supported employment problems, that the employer is going to be identified as retaliating against the employee for blowing the whistle. The Federal False Claims Act has an anti-retaliation provision that allows employees to go after employers and get 2 times damages where they've been wrongfully terminated. State False Claims Acts have the same provisions. There's at least a dozen federal statutes that protect whistleblowers' rights to go forward and report wrongful conduct to government agencies. Many states have common law protections, that is court-created protections, and these protections are called discharge in violation of public policy, and it's therefore unlawful. It's a civil wrong for an employer to discharge an employee who has stepped forward and taken action to report an employer for engaging in wrongful conduct. It's not to say that it shouldn't be a concern of an employee. It's an obvious concern. It's a real concern. And although there are these statutes that make retaliation unlawful, there's no guarantee, obviously, that an employer is not going to do it. But it would be an imprudent or an irrational thing for an employer to do, to lash out and retaliate it against an employee where the employer knows that the employee has reported the wrongful conduct to a regulatory body.